who try and keep not only the superintendent and some of the administrative staff with information, but the school board as well. I don't know how you guys do it, but I can't thank you guys enough for the job you all do, because you just don't get things done otherwise. The culmination and funneling of information to you guys and how you disseminate it all is just superb. So thank you all for your jobs, and also keeping up to date every year with moving targets and the information you guys get from here. It funnels back to the school boards as well. So thank you for being a conduit of information across the board. Thank you.
Thank you, Robert. Yeah, you definitely are the unsung heroes, believe me. So thank you, Robert. And Heather, we've got our 25 people here. I think Charlie, where's Charlie? We okay, Charlie? I think everybody in?
I'm pretty sure, yeah.
Okay. All right. Without any further ado, then we've tried to do let people know where we are, where they're coming from. So can we do that, Michelle? Can you just let Heather know what district you represent?
Riskany Central School District.
Pam Manning,
Stockbridge Valley.
Tammy.
Vernon Verona Cheryl.
Thank you. Ms. Scharf from New York Mills.
No, Stephanie, it's all good.
Okay. Oh, yeah. Joe, we know Joe. Michelle Goodman, Jody Chantel from Morrisville. Valerie. Can Valerie hear us?
On Patton.
Oh, HP. All right. Marilyn. Is she Tracy? Where's Tracy's, I believe, Madison, right, Tracy?
Madison Central. Yeah.
Yes. Yeah. It only seems like you've only been there for a lifetime, Tracy.
Feels like a light year.
Julia?
Yes, I'm here from Clinton.
Oh, Julia, yes.
Now, why does everybody have that reaction, Jim?
Oh,
Maybe you better call me.
that's a good one, Julia. Thank you so much. And then after this, you can go mute and screen. So we've got Joe, right? Joe Morales. Michelle, Deb Kimbo. Deb is another Deb, how many years now?
31. 31.
Oh, wow, Deb.
That's
nice.
impressive.
Impressive.
Whoa.
Good morning, everyone.
Congratulations. Yeah, Kim doesn't have an audio hookup. Miss Matthews?
Utica.
Aha. Yeah. Oh, boy, God bless. Yeah, hopefully with the foundation aid, things can change there a little bit,
Yes, hopefully.
Yeah, hopefully. I think so. I think you're in great shape.
Yes.
Susie Steele?
Yep, I'm here from Herkimer.
Oh, all right. Yes. Schweizer? Is it Kim Schweizer?
Kim from New Hartford.
Aha. Okay. Yes. Thank you for coming in. And we have Miss Wellington.
Hi, Jim, from Poland.
And how many years up there?
33 it'll be in September.
I was
15.
gonna say,
Wow.
yeah, I thought you and Deb are just about, yeah.
15 as district clerk and 18 in the business office before that.
Yeah. Wow. God bless.
Thank you.
And we have a phone number, 315-429-3155.
Sandy from Dalzell Central.
Hi,
Oh, hi,
Sandy.
Sandy.
Hey, thank you. And Sandy, I've got that one situation we're working on. We have that cleared up for you. Okay. So.
Okay, great. Thank you so much.
Thanks, Sandy. All right.
Excuse me, and this is Susan Morales from Utica.
Oh, hi. Oh, hi, Susan.
It's my husband's laptop, so.
Yeah, we've had kids, we've had grandkids. Yes, Susan, no
Right,
problem.
right, okay.
Thank you so much. And again, God bless you over there. I was at Kennedy for a year. So
Yes, you were.
it was a great run, Susan.
Yes,
Great
I'm
run.
sure. I'm sure it was.
Yeah. All right. Without any further ado, where is Heather? There she is. All right, Heather.
All right. Good morning, everyone. I'm going to try to share my screen. Dun, dun, dun. Oh, not now. Come on. There we go. Everybody can see?
I think we got it, Heather.
All right. Do you see me on the side or
Yes.
just, okay, perfect.
On the
All
side.
right.
Yep.
Well, good morning, everyone. It's nice to be here again. I'm not sure how many years it's been for me doing this, but as soon as today is over, I'm going to put next year's date on my calendar because this is something that I kind of anticipate doing every year and that I enjoy doing. I like working with the district clerks and answering your questions, making sure you're kind of prepped as we head into election season and as we continue to navigate COVID. So overview for today, some legal updates. This is, we didn't have as many legal updates that I thought were applicable to you as district clerks as we've had in some previous years. I think during the pandemic, there were a lot of things that mattered to you folks. This year we have maybe a little bit less, but things nevertheless that I think are going to be important for you to hear about. Of course, we're going to talk about my favorite topic, school elections. Just a reminder about SROs and school safety plans and code of conduct in terms of timing so that you can make sure that you have that on your respective calendars, your board's calendars, your superintendent's calendar. And then to the extent we have some time, questions. I think maybe there was one question that came in, but I'm not sure Charlie received too many more questions that you wanted me to answer, but hopefully we'll have time at the end to do that if we need. All right, so there was a commissioner's decision regarding board member removal. And to start out by remembering that there are two ways that a board member can be removed from office, either through action of the Board of Education itself, and it requires a hearing before the Board of Education to prove that the board member engaged in behavior that was worthy of removal, or the board can petition to the commissioner, essentially, and say, Commissioner of Education, you please look at this, you determine if the individual needs to be removed. This is a situation where the superintendent discussed in executive session, and this was during COVID. So this was, I believe, summer 2020. So when COVID is kind of at its peak, executive session discussion of the town's request of the school district to use school facilities for a summer camp. Okay, what is the alarm bell going off on all of our heads right now? Is this really something that fits into an executive session category? Probably not, right? So they have this discussion in executive session, and the superintendent had his reasons for having that discussion in executive session. This was kind of a local political issue, right? Is the school district going to let the town use school facilities for summer camp during, this is right after schools were closed for the end of that school year, right? This is the summer of 2020. And then what happened is some of the discussion from that executive session was disclosed by a board member to the town supervisor. And essentially this board member says, hey, friend of mine who's the town supervisor, just wanted to let you know, they're not going to approve your request. They're not going to let you use school facilities for summer camp this year. And the board finds out about that and says, you know what, you disclosed confidential information from executive session. That is improper. We are removing you from office for that. And they followed the procedure that the education law sets forth to have a board remove one of its own from office. And the board member said, wait a minute here, you can't remove me for this. We weren't even properly in executive session. I didn't disclose anything confidential because guess what? That conversation wasn't confidential. You shouldn't have been having it in executive session. Initially, it goes to the courts and the courts kind of bat the issue around a little bit. And eventually it winds up before the commissioner. And the commissioner says, you know what? You're right, board member. That was not a proper subject for executive session. You shouldn't have been discussing it in executive session. And because none of the conversation was confidential, there's no breach of confidentiality by disclosing it. So what's the lesson to be learned here for district clerks? This is a hard position to be in when you note your board may be steering out of bounds for what is a permissible subject in executive session. Be cognizant of it. have a method that you and your board president, perhaps you and your superintendent use to signal that we may be entering into territory here that is not appropriate for executive session. That of course assumes that you're in executive session to begin with. Sometimes you are and sometimes you're not, as the board clerk. But if you feel things veering in a direction that they should not be, it's a good idea to be aware of that, make those that are participating in the executive session aware of it, and stop discussing that in executive session, because it's not a proper reason to be there. And then even if someone were to, I'm going to use air quotes here, breach the confidentiality of that discussion, the commissioner says there's no confidentiality to be breached because you weren't properly in executive session to begin with.
Hey, Heather,
Yes.
I know as a former superintendent, you almost need a board member to be like the executive committee policeman, so to speak. And what they need to do as they start to drift away from what is allowed, they need to say, hey, listen, we need to come back here because we're really getting out of bounds. So.
Yep. I think that's a really good strategy to employ. It's just as uncomfortable when you're the attorney in the executive session and it starts veering off track. Let's talk a little bit about gender neutral facilities. First thing I want you to understand about this is this does not mean you need to create new gender neutral facilities. You don't have to create anything that you don't have. But what is required now is that school districts and BOCES clearly designate all single occupancy bathroom facilities as gender neutral. All right, so if you don't have gender neutral signs on your restroom, whether it is a student restroom or a staff restroom, they need to be there. There's also supposed to be a policy and procedures for designating all single occupancy bathroom facilities as gender neutral. And it's indicating that they're for not more than one occupant at a time or for family or assisted use. And I raise this just because you might be the folks responsible for ordering the signs or, assisting with making sure that policy or procedure is on the board's agenda. So if it's not something that you have handled thus far in your school district, something to be aware of. I've copied and pasted into the slides here. These are the state education department's preferred signs for those facilities. This is what they would prefer your signage to look at. These images are available actually on the facilities planning website. They're a little bit buried, but they're on facilities planning. And then this is what they've deemed acceptable signs. So I just thought it was interesting that we have, this is what we would prefer you have. If you don't have it, this is okay. So just in general, I don't know that you need to, advocate for going out and purchasing all new signs if you don't have anything that matches exactly with these. I think the more important thing is that your single occupancy restrooms are designated as gender neutral in some way or fashion. Okay, friends, let's talk about masking. Yesterday was a big day in the masking world. And it went by a little bit without notice because it was break week. All right. The bottom line is masking in schools is still, we believe, currently in effect. And I want to talk to you a little bit about how we got there so that you have it in your minds and you understand where we might be going. All right. So towards the end of January, on January 24th, there was some litigation out of Nassau County where a Nassau County judge, and keep in mind, that is the lowest level trial court in New York State, or county court levels. A Nassau County Supreme Court, don't be fooled, because we're crazy here in New York. We call our lowest level court Supreme. It's not our highest court. That's called the Court of Appeals. But a Nassau County Supreme Court judge said, you know what? The manner in which the governor and the Department of Health implemented the masking requirements was done unconstitutionally. It's not that masking is unconstitutional per se, it's the way they went about it is unconstitutional. That happened on January 24th. That same day, the New York State Attorney General's office on behalf of the state files a notice of appeal. Generally speaking, when a notice of appeal is filed, a stay of enforcement is in effect. It's as if, the status quo, whatever issue has been challenged in the litigation, no changes are being made as a result of the litigation until an appeal is decided. That's generally how it works. And then in that evening, the Commissioner of Education issued a public statement saying, you know, the status quo remains. There is what's called a stay of enforcement in effect pending the appeal. Everybody wear your masks tomorrow. The next morning, it must have been attorneys at the state level looked at things in a little more detail and said, you know what, this might be one of those somewhat rare circumstances where there is not an automatic stay of enforcement. And so we better ask the courts to make sure that we have a stay of enforcement so that masking remains a requirement while this litigation is pending. And that happened the afternoon of January 25th. So the next day, there was a hearing that was live streamed. Some of you may have even watched it. I know we were watching it here in this office. And what happened as a result is the judge issued what's called a temporary stay, saying, all right, I'm issuing an emergency stay until you more fully brief us and apprise us of the issues here. So there was a more full briefing schedule, and it went to a panel of judges. And that panel of judges, a handful of days later, said, okay, you know what? Yes, there is definitely going to be a stay in effect until this appeal is decided. What that means is the masking requirements are still in effect, even though they've been challenged. And even though a Supreme Court judge found the procedure by which they were implemented to be unconstitutional, they're still in effect until we decide if in fact the way it went about was unconstitutional. And what that order said is the Attorney General has to file all the paperwork and do what's called perfecting the appeal on that issue by March 2nd. The problem with March 2nd is that the regulation at issue was going to expire Monday, the 21st. And so the question was, is the state just going to let the regulation expire? Are they just going to let it go? Right? Be Elsa, let it go. Is that what they're going to do? They did not. There was in another emergency regulation adopted and sent to the governor's office in effect as of yesterday. All right. So as of yesterday, the state has decided, you know, we are renewing this regulation that involves masking. It's still in effect. We are actually in our office looking today into issues of whether a new directive under that regulation needs to be implemented as well. Because what you have is a Department of Health regulation that says, I am delegating authority to the Commissioner of Health to decide where and under what circumstances masks need to be issued. Now that the regulation authorizing the Commissioner of Health to do that has been extended, is the Commissioner of Health going to change what the requirements and circumstances are for when masks need to be worn? I think the bottom line is right now, your folks should be wearing masks in schools, but stay tuned because this is very rapidly evolving. This involves very complex legal issues that, you know, lawyers really think hard about to determine what are the rules right now. It's not nearly as clear cut as perhaps it should seem like it should be in terms of determining, well, is that regulation in effect? Is it not in effect? What effect does the notice of appeal have? Is there a stay? So right now, that's where we're at, but stay tuned because it's literally changing on a daily basis. COVID-19 testing. I brought this up just to make it clear that weekly testing for those who are not willing to provide proof of vaccination status, that is still very much in effect right now. All right. The regulation that was challenged relative to masking is separate and distinct from the regulation that requires the weekly testing. All right. The requirement for weekly testing was not part of that litigation. So that is still in effect. And I just wanted to make sure everybody understood that because I also know that lots of times you as district clerks are the folks that are, you know, maybe collecting the tests and labeling them and sending them out for processing and that sort of thing. Maybe responsible for some record keeping in that regard. That is still very much a requirement. FOIL updates. One, I did look at the Committee on Open Government's website because they do you know, post a lot of updates and decisions of import that they think the field should be aware of. And they didn't really have much this year in terms of FOIL updates. But what I do want to touch on is the fact that many of you, maybe even all of you, have received Freedom of Information law requests for surety bonds in your school districts and oaths of office for, you know, either the board members, other administrators, you know, others in, you know, you as district clerk. Most clients that we represent, and we represent about 150 school districts and BOCES, have received some form of this request. And it may be in connection with COVID-related health and safety protocols. There seems to be some sort of belief that the surety bonds and oaths of office, if they are potentially not in effect, that that's somehow a violation of legal requirements, and somehow that ties to the ability to enforce masking requirements. All right. I think the bottom line is here, if you have received those requests, please make sure that you are acknowledging them and addressing them as FOIL requests, but work with general counsel. Okay, we have kind of a database of folks who have received this request. To the extent they are copied and pasted amongst people on the internet, there is a somewhat formulaic way of being able to respond, of working with your insurance carrier to make sure that you provide information that's responsive. Work with general counsel on that to make sure that it's handled timely and appropriately, and with an eye toward what is actually being requested and what are you obligated to provide. Some general reminders for FOIL. Remember, your 5-day letter acknowledging receipt needs to be sent upon receipt of the inquiry. If the email is date stamped at 10 p.m. that night and you didn't check your email until the next morning, that's when you start counting, right? You are required to provide a full response within 20 business days. However, we all know that you can extend that if you need to, right? You just need to provide a date certain by which the records are going to be available if you need more than 20 days. Only provide what's already in existence. You know, we talk about this. You are not required to create a record that does not exist in response to a FOIL request. And that connects to kind of the fourth bullet on this page. A Freedom of Information Law request is not an ask for an answer to a question, right? It's a request for a document or record maintained by the organization. And I know that lots of times questions, letters are received that want you to provide information, but aren't necessarily asking for a document or record. And so you need to just be mindful of what is being asked for, and can you treat it as a FOIL response, because there is some sort of document or record that would provide the information that is being requested. Or if it's just an answer to a question, that's a matter of internal discussion with your superintendent and your board as to what obligation or standards you're going to be using to just respond to public inquiries, right? Because just a general inquiry or a question is not necessarily a Freedom of Information Law request, and vice versa. You can charge if you need to redact materials before sending them out, because the rationale for that is this. If I have a document that's maintained electronically, I may need to print it, physically redact it in some way, and then make a copy of it with the redaction so that you can't hold up the piece of paper and see through what the redaction is. And in that circumstance, you are allowed to charge for copies. Now, you may be able to use Adobe or something like that to put electronically make redactions, but anytime you need to print something for purposes of responding to the request, need to print something is the key phrase, you do have the ability to charge, even if ultimately the response is going to be provided electronically. We had some more updates under the open meetings law this year. So we have a bunch of amendments from kind of actually I'd say maybe the first few months of the school year, September through December. We had the legislation that authorizes public bodies to meet and take action without being a person via conference or call or similar service, so long as the public has the ability to view or listen and the proceedings are later transcribed. This sounds really familiar, right? Because this is essentially mirroring all of those executive orders that we had at the height of the pandemic that allowed for virtual meetings. What this did is take some of the language from all of those executive orders and make it statutory, right? It's now a law. It's only effective through March 16th. Okay, so you've got, a little under a month, right? Where that is still the law. Also possible it would be extended again though, right? Remote participation, we just want to highlight that's distinct from virtual meetings. If someone is participating in what is otherwise a live meeting virtually, that's different than conducting a virtual or remote meeting. You have situations where an individual board member may participate remotely. The most common example of that is someone is on vacation, right? Your board's meeting in person and they want to call or video into the meeting. Your notice of your meeting needs to include their location if they're going to be doing that, and their location must be accessible to the public. So if I'm a board member and I'm on vacation in North Carolina for the date of the meeting and I want to participate virtually, I better find a location that's open to the public and notify my board and my district clerk where I'm going to be, and they need to publish that information so anybody that's where I am can come with me and watch me participate in this meeting. A reason why you don't necessarily want to do that from your hotel room, right? Or from your Airbnb or from your relative's house. Consider how that's going to work if you need to have an executive session, right? The person is going to need to go to a place that is completely private and confidential in order to have that discussion. That you can't have anyone overhearing. And that goes for, all right, you know what? I walked down the street to the public library. They had a conference room for me. I did the public part of the meeting from there. Now I'm going to walk down the block and I'm going to go home and do it. Well, you better make sure that you're not doing it in your kitchen and your family are walking in and out of the kitchen to grab a glass of water or get a snack while you're doing that, because they can't overhear you. All right, you have to make sure that if people are participating remotely, and this goes for both remote participation and if you are conducting a virtual meeting, that people cannot overhear them and cannot see them when they are engaging in executive session procedures. It's really, really important. I have been known to walk out of my house and sit in my car in my garage and have executive session discussions, either on video conference or by phone with boards, just because I have kids and a husband and who knows where they're going to show up in my house, and I want to make sure that I'm not going to be bothered and I'm not going to be interrupted, right? So something to think about when people are participating remotely. Another open meeting law update. This one you're probably familiar with from October, requires records to be discussed at a meeting to the extent possible to be made available either upon request and online at least 24 hours prior to the meeting. All right, so this was the old, you have to make them available as soon as possible before the meeting. This doesn't change what you need to be making available. It changes how soon you need to make it available. You have to make it available at least 24 hours before the meeting, online or upon request. If you use board docs and you have that publicly accessible information component, that's how you do this, right? If you have any questions about whether something can or should be disclosed publicly before a meeting, call general counsel's office and talk about it, right? If you have a negotiated disciplinary agreement, for example, that's probably not appropriate to be posting publicly until final board action on it, until it's been approved. All right, so there are things that you need to be mindful of that should not be posted and made available in advance, with the understanding that the overarching goal here is transparency, right? The goal is to make sure that the public has this access to the same information that the board does before the board is called upon to make a decision. Another open meeting law update. This one is from November. This one requires to post your meeting minutes on your website within 2 weeks of the meeting or within 1 week of an executive session if you maintain a website and use high-speed internet connection. Most of you probably do that in this day and age, right? If not all of you. So what this requires is, it used to be that your minutes need to be simply made available. Now you got to post them. Again, board docs is a great place to do that, right? You can clearly mark them as draft if you have a procedure under which the board approves and finalizes minutes, but you need to make even draft available within 2 weeks. Within 1 week of an executive session, really what that means is that you're making available the fact that the board went into executive session, because other than involvement in a 3020A proceeding for a tenured teacher, you're not taking any action in an executive session that needs to be memorialized or that should be memorialized. And even with a 3020A, all those documents are kept confidential by law. So really it's not, what was discussed in executive session or some sort of synopsis of what happened in executive session. It's the fact that you went into an executive session that needs to be posted within a week. Now, the nice thing about this is if you have a video recording, you're live streaming your meeting perhaps, or an audio recording, if they are unabridged, meaning unedited in any way, or you have a transcript, that can constitute your minutes for this purpose. All right, so that is made available electronically. Your written draft minutes or your written minutes don't necessarily need to be. All right, so something to consider if if you leave your meeting minutes or your meetings available on a YouTube link, and you don't edit or change them anyway, that will satisfy this requirement. All right, we had another change in December, which amended the definition of a public body to include committees or subcommittees performing a necessary function in the decision-making process. So if you have any questions about this, call, general counsel's office and talk about it. But essentially, I'm thinking of things like an audit committee, right? Or a budget committee or a finance committee. And depending on the level of their decision-making and what they do in the manner at which it gets referred to the board, that may be an open meeting, right? That needs to now be noticed and conducted in accordance with the open meetings law. So something to be aware of there. We wanted to talk a little bit about public comment at board meetings because for some of you, maybe for a lot of you, board meetings have become a little bit more contentious and folks have become a little more outspoken. And so some thoughts and strategies for how to address that and, to a certain degree, manage it, right? Your board policy probably has a requirement for public comment at board meetings. Understand that there's no requirement under the open meetings law that you allow public comment at board meetings, but you probably have a requirement in your own board policies, or at the very least, a practice of doing this. And, I'd also suggest to you, it's not a bad thing, right? To have public involvement in the process and for your elected officials at your board meetings to hear what the public's concerned about. The difficulty is when it spirals out of control, right? So you can put reasonable time, place, and manner restrictions on the ability to speak publicly or introduce public comment at your board meetings. And I think most of you are probably very familiar with this. You can do things like designate the amount of time per person, requiring notice in advance of intent to speak, setting a maximum amount of time for public comment session overall. Yes.
Heather, we lost you for about a minute.
Oh.
You froze for about a minute. Can you go back then, please?
Sure. You can impose reasonable time, place, and manner restrictions on public comment. Those are things like setting a designated amount of time per person, providing notice in advance of your intent to speak, a maximum amount of time for public comment session as a whole. When will your public comment occur? Lots of times boards set it at the beginning of the meeting. There's no reason it has to be there. It could be at the end of the meeting. I'm also aware of some boards that do both, right? And maybe have public comment at the beginning of the meeting that is limited to something that's on the agenda for the board's consideration, and then a second public comment at the end of the meeting that's for anything else, right? And it's also okay to make sure that you're enforcing civility requirements. You have a code of conduct on your board property, right? In your school district property that requires people to act in a particular manner. The code of conduct is not just applicable to students, it's applicable to anybody on school property, and that includes your guests and visitors at your board meetings. And so if people are not adhering to those standards, they can be, reminded of the standards and in extreme measures removed from the property. That's really something that you should be planning in advance if you think something like that is going to happen and have a plan in place for how you address that situation, but it's something that can occur. The most important thing is that you treat everybody equally. If you're going to have these sorts of rules, they need to be applicable to everyone. You can't allocate 3 minutes for everybody to speak, but allow the person who is speaking in glowing terms of how wonderful the school district is to go on for 3.5, 4, or 5 minutes, while everybody else who was critical only got their 3, right? Can't do that. In terms of content limitation, just remember that if you are curtailing speech in any way, you are potentially implicating the First Amendment right? What you've created by a public comment session at your public board meeting is something called a limited open forum. It's different than an open forum, a complete and true open forum, which would be like a street corner, right? Where someone can stand on a street corner and say and talk about what they would want. So your content limitations are going to be circumscribed by the First Amendment. What you can't have is discussion that violates another person's rights. You can't have discussion that incites a substantial disruption to your operations. You can somewhat limit to matters that are on the agenda or before the board that evening. But again, like I touched on before, there may be other issues that the public wants the board to be aware of and or attend to, and you may want to make sure you reserve some additional time for that as well, right? That's the idea of potentially having 2 public comment sessions, one for discussion on agenda items, which, you know, logically you'd want that to happen before the board actually acts on those items, so they could understand, hear, and consider public input before they make a decision. And then other issues that are maybe not on the agenda, perhaps that could be saved for later in the meeting. Okay, elections. Let's just quickly remember military ballots. They went into effect for the 2020 election, which you know, very much got lost in the difficulties that were the 2020 election at the height of the pandemic. So my guess is that for most of you, 2021 was the first year that you really kind of maybe paid attention to military ballots. I'll tell you that of all the school districts we represent and the handful of us here at the firm that kind of specialize in election issues, I'm not sure any of us have had an inquiry from a school district for a military voter who has actually requested a military ballot. It may be because service members are just not aware of it yet and are not aware that it's something that they could do. But military ballots are available to service members, spouses, children, or dependents under qualifying circumstances. The voter can designate their preference for receipt of the ballot by mail, email, or fax. And we have talked about, I just want to make sure, we're not going to talk about it in great detail in this presentation, but if the voter elects to receive the ballot itself by, say, email or fax, they're going to have to get it back to you in an envelope that has all of that required language on it, right? The one side that has the oath and the flip side that has kind of the name and the date of the election and that sort of thing. And so what you may need to do is send that voter a piece of paper with that information on it that they can print out, cut out, and literally tape or glue to an envelope so that that information is on the absentee ballot envelope when they return it. If you're in that situation, you know, give us a call. We'll talk you through how to do it. There are special deadlines for transmission of military ballots, generally a function of the fact that if someone is requesting a military ballot, they may be overseas and it may take longer for the ballot to reach them and or for them to send it back. You're required to reference the availability of military ballots in your annual meeting notice. My guess is you all have that notification in your annual meeting notices now, because this will be the 3rd year where it's technically been required. If you have any questions about it or are wondering about it, you know, give General Counsel's office a call. We'll talk you through it. Okay, talk about absentee ballots in general. Military ballots are kind of like a form of absentee ballots, but this is general absentee ballots. You have to remember whether you're a school district using a system of personal registration or a school district using a system of poll registration. In personal registration districts, that means people need to be in your poll book and registered to vote either with the county or with your school district in order to vote at your election. If you use a system of poll registration, I can show up the day of, and it doesn't matter if my name is in any book, I'm allowed to vote so long as I can represent that I'm a qualified voter. If you have multiple election districts, I can almost guarantee that you are a district that uses a system of personal registration. Most other districts use a system of poll registration. If you have any questions about which one you are, give us a call. We'll talk through it. It's confusing and it's not unusual for a district clerk to wonder and to ask the question. So we can absolutely call and talk through it. If you are using a system of personal registration, you have to have voters use the ballot application form that's available on State Ed's website. I'm going to click the slide in a minute and you're going to see what it looks like. If you are a system using poll registration, you're going to use your own internal document, the same you already have. If you have any questions about what should be on the application, again, happy to call and talk that through. This is what the application looks like on State Ed's website for those of you using a system of personal registration. This is the form that must be used by those folks. Do you need to send an absentee ballot to every qualified voter this year? No, you do not. You are not in the height of the pandemic anymore. You don't need to do that. What about fear of contagious disease as grounds to obtain an absentee ballot? So this is an interesting question, because last year in 2021, there was legislation that effectively said concern about contraction of a contagious disease qualifies as a medical reason, right, to not receive an absentee ballot. It allowed you what I think of as the medical exception, right? Okay, so that legislation expired in January of 2022. What is in effect now is nothing, but there is legislation pending. There has already been legislation approved that is specific to villages and village elections that extends the concern about contraction of a contagious disease as a qualifying medical reason to receive an absentee ballot. That's already been approved for villages. It's I can't remember if it's been through the Assembly or the Senate with respect to schools. It's been through one of them. It's making its way through the other. Assuming that it is approved in both houses, it is likely to be transferred to the governor and signed into law. I think there's a fairly good chance that fear of COVID, for lack of a better phrase, is going to be a qualifying reason to obtain an absentee ballot for this year's election. The legislation just isn't in effect yet. What does that mean for you if you have a referendum coming up, or somebody asks you for an absentee ballot application now, right? They're just on the ball and they want it for the May election now. You send out your application, and if it comes back with the medical exemption checked, it's not your obligation to look behind it and try to figure out, did they do this because they think fear of COVID is a reason? And that's not really a reason for us yet. We haven't had legislation to prove it. You don't need to get into that. You can take the application at face value. It's the individual's obligation to complete it completely and in an accurate manner. If for some reason you believe the person, let's say you ran into the person in the grocery store and they said, oh yeah, I completed my absentee ballot and I just checked the medical exemption because I know fear of COVID is still out there, except oops, we don't have that legislation in effect yet. And now you know that. Now you know that that's what the person has, their rationale for their absentee ballot. That's what the voter challenge process is for on the night of the election. Okay, that's when, before absentee ballot envelopes are opened, anyone can raise an objection to someone who is voted by absentee ballot. And that's the time at which you say, you know what, I ran into so-and-so, their reason for submitting it was lack of COVID. That was not a qualifying reason at the time. And so I'm challenging that ballot. Hopefully you don't have to get into any of those situations. Hopefully we have legislation soon that is approved and so you don't have to worry about this. If you have that circumstance and you want to talk it through, please give us a call. I know I've been working with one of you, I won't shout out any names, where somebody actually, people are actually writing COVID on their absentee ballot application. We can talk about those things. We can talk about how to process them, but understand that in general, it is not your obligation as a district clerk to investigate whether someone was correct or telling the truth based on how they filled out their application. General election issues, what can be used as an electronic voting machine? Please just make sure that you're using one of the approved forms of machine, like a Scantron or a copy machine. Can't be used as an electronic voting machine. I think there were some school districts that did that in 2020 because they felt like they had no other choice, because they couldn't get an electronic voting machine and they were having tens of thousands of paper ballots. But in general, you've got to make sure that you are using an appropriate machine and contracting with your county, or perhaps even an adjoining county to do that. Obviously, we're all very familiar with the publication of our legal notice. I've already reviewed a few this year, people who are really on the ball. I want to make sure that they have their language correct before they get their first publication in. Propositions. If you anticipate any propositions on your ballot that would require bond counsel review or any form of legal review, you really need to be making sure your board is acting on them now. Ideally even before now, because what you don't want is a situation where shortly before your publication deadline, you send something to bond counsel or general counsel and they say, ooh, you need to tweak this language. And now you need to go back and get it board approved, but it also gets in the newspaper, but the language is going to be a little bit different. It's not the end of the world, but it's a situation that you'd rather avoid if you can. And so I strongly encourage, and any of you that participated, and we did kind of a district clerk webinar, I don't know, a month, 6 weeks ago, to kind of have it on your own internal calendar that by winter time, you should be having a sense of what propositions are going to be on your ballot so you don't run into that issue. I realize that may be a little late in the game because you haven't, or a little early, excuse me, because you haven't, done your budget yet. But to the extent you can do that, it's a really good idea. Nominating petitions, people are going to have to nominate themselves this year. This is not like 2020 where, I could just basically nominate myself and I didn't need to get any required number of signatures. Make sure that you've done the vote count for last year and you know what 2% of your vote count is for last year. And that you know what 25 versus 2% is and see how many names people need on their list. If you're a small city, you need 100 names. Don't worry about 25 versus 2%. The rest of you who are not small city know exactly what I'm talking about. And it's a good idea to encourage candidates to get a few more names than they actually need on the petition. So in case something is illegible, in case there's an allegation that somebody on the list is maybe not actually a resident of your school district and is not qualified to sign the petition, get a few more signatures than are actually needed just so you don't need to worry about it. There are still rules for employee voting leave. Employees are still allowed to leave to vote on the day of the election if necessary. Generally not something that you as district clerks are going to need to monitor, but it may be something that you work with your superintendent on. We talked a lot about the LGS1 last year, which is the new records retention schedule that supplanted the ED1. Just wanted to, bring this to your attention, have this again. It really didn't change anything with regards to what you need to maintain for school election purposes. You got to keep a sampled ballot for permanently. You got to keep your voted ballots for a year. You have to keep them locked in the ballot box for 6 months. You got to keep them for a year. Your application for absentee ballots have to be kept at least 30 days after the election. That's going to make a lot of sense if you think about it, because what's the time frame for someone to challenge your election? It's 30 days after the election. They can bring an appeal to the commissioner. So what this is saying is, if somebody hasn't brought an appeal in 30 days, you don't need to worry about keeping your absentee ballots anymore. Got to keep your final results permanently. Intermediate records, those are what I call like maybe your scratch worksheets where people are keeping notes and kind of keeping their tally sheets of votes and records as they count ballots. Keep those for a year. Unused ballots, so that's you had 500 ballots made and you only use 200. Keep those other 300 for a year, or I'm sorry, for 6 months. And then spoil, voided, or rejected ballots. Those are, someone mismarked their ballot and they brought their mismarked ballot to you and said, can I get another one? You're keeping the spoiled ballot. You're keeping any ballot that, was not properly scanned, or for some reason was void because, maybe the person drew a big smiley face on it. Anything like that, you're going to keep for a year.
Heather, we got a question.
Yes, go ahead.
Is it necessary to include the voter's phone number on the poll list?
No.
No. Okay.
No, and actually I'd almost suggest that I'm not sure what authority there is to do that.
Okay.
I'm not sure that you have authority to require them to give you a phone number. This is just a reminder, once you get through election season and now you're headed into annual meeting season and summer work, just remember that if you have an SRO agreement with either, the county sheriff or local law enforcement, the SRO agreement needs to be included in your school district safety plan. It can be included as an addendum, that's fine. But just remember that that needs to happen every year. The agreement itself needs to be approved and needs to be incorporated into the safety plan. There are certain requirements for what that agreement must have. You have to define the role and responsibilities of an SRO in that agreement. You also have to make sure that there's ability for stakeholders to comment on the SRO agreement. That's things like, unions, parents, those sorts of things. So the whole idea is, if you need to have an SRO agreement in place by the beginning of the school year, and your SRO agreement needs to be incorporated into your safety plan, and your safety plan requires a public hearing, and your SRO agreement requires stakeholder input, you got to give yourself time to get all of that done before the deadlines. So it's just a reminder, by the end of the school year, you really should be thinking about when you're going to be holding public hearings and when you're going to be soliciting comments on those things so that it gets done over the summer before everything is approved and finalized. One thought on your code of conduct, which is also something that is supposed to be reviewed annually by your Board of Education, and it's supposed to be reapproved. It must be reapproved if you make any changes to it. Some changes that we're seeing a lot of right now have to do with the dress code, making your dress code language much more gender neutral, right? And then also information regarding hairstyles, protective hairstyles, and the Crown Act. Crown Act is a term that's being used nationally to describe legislation that states are adopting to reflect that hairstyles typically associated with race or protective hairstyles such as braids, locks, twists, discriminating against someone based on their hair is also a violation of anti-discrimination laws. It would also be a violation of DASA. And so we have adopted a version of the Crown Act here in New York. I believe it was last calendar year sometime. No, would have been calendar year 2021, I believe. Where it was adopted. And so if that has not been incorporated into your code of conduct, something to think about, something to red flag. And as long as you're doing that, maybe looking at your dress code language and, working, encouraging administration and the superintendent and the board to look at perhaps making it more gender neutral, something that we're seeing a lot of now and that we're helping school districts with. That is the extent of my actual presentation. Got done a little bit early. There may be one more question up there, but I'm happy to take questions before we call it a morning.
Heather, can you give us a time frame? I know you talked about the safety plan and the SRO. So what's your suggestion?
Yeah, you're going to ask me that, Jim. And I want to say the safety plan has to be, there's a deadline in September or October, I believe, for the safety plan. And so my thought would be usually, an SRO agreement could be something that is maybe part of your annual reorganization meeting, or at the very least, something that happens over the summer. Right. But you should be soliciting stakeholder input on your SRO plan at least over the summer, so that you have that approved and done so that it can be incorporated into your safety plan. Usually the safety plan, I think the public hearing is like August-ish, right. Sometimes on that, to make sure that it's ready for the fall.
Okay. All right. Thank you. And your review of the public participation and public comment. Again, oftentimes I've worked with some districts that had problems with that. And I said, well, let's take a look at your policy. And the policy was fine. They just weren't following it. So oftentimes, Heather, with that issue.
That's a really good point. Start with your board policy. What does your board policy even say about this? And are you adhering to what's in writing? Right. And if you want to change what's in writing, make sure you go through your policy procedure to do that. Because where school districts get in trouble with the commissioner is when they violate their own policies. right? You got to know what your own policy says. And as a bit of a tangent, sometimes you have a lot of policies and it's really hard to remember what all of them say. If you're going through any sort of policy audit, review, update, really think about what policies you need versus what policies are a restatement of the law. The law is going to exist without your board policy. And you don't necessarily need a board policy to restate certain aspects of the law. And so consider whether you actually need it. Because the other problem with that is when the law changes and is updated, you got to update your policy too. And what's the likelihood everybody's going to remember to do that? If you have a policy service, they're usually pretty good, about sending you updates and doing that. But it is worth thinking about, do you need as many policies as you have?
And you know what? That's a great segue. That Christine from Madison BOCES is following up with our policy piece. Here's a question though, Heather. Yeah. If a board member goes out of town and joins a board meeting virtually, you indicated that we need to advertise that they are joining from a specific location where others could join them. Would it make sense to advertise that locally where the school district is located if the board member is in Florida?
That is a great question. Because if they're not in New York State, what's the likelihood that anyone in New York State is going to drive to North Carolina, right? For the purposes of being in the same room. It doesn't necessarily mean publishing a legal notice. I think in this day and age, having information on the kind of Board of Education segment of your website indicating that so-and-so will be participating remotely and here's where, to the extent you use social media, do that. To the extent you use something like Parent Square or another, communication tool, when you send out, reminder, there's a board meeting tonight, add a little, and so will be participating virtually from insert here. Right. That's probably your best bet.
Okay. All right. Thank you. Can you go back to OML? What qualifies a discussion item that needs to be posted with the agenda?
Okay. There is no requirement under the open meetings law that you have an agenda for your board meetings. Shocker, shocker, shocker. There is not. What there probably is a board policy that talks about having an agenda for your meetings. And so you'll need to look at your board policy and see how your agenda is described and what's contemplated on it. If you have questions about how to word something specifically for the agenda, like let's say a common one I deal with a lot is there has been maybe a 30-28 disciplinary proceeding that started against a teacher and we've resolved it, right? There's going to be a settlement agreement without the need for a hearing, but the board needs to approve of that agreement. In order to protect the privacy of the teacher involved, usually what the agenda item is something like review of disciplinary agreement with a tenured teacher, something generic like that. And then the resolution is usually resolved upon recommendation of the superintendent of schools, maybe as discussed in executive session, the board approves of a disciplinary agreement with a tenured teacher, something along those lines. Council can help you in those particular situations. It is very common for me to be corresponding with the district clerk about here's the final version, this is what the board's going to need to review, and they write back and say, what's the best way for me to describe this on the agenda, and we work through it. I also understand that sometimes I've learned a little bit about how board docs works that I didn't necessarily realize before, and that sometimes you don't have as much control over the distinction between how it will appear on your agenda versus what the resolution will look like. And so if that board docs is a great tool, right? But if it doesn't give you kind of the discretion or the options that you're looking for, give us a call and let's talk it through. Right? Because I do understand that can be problematic. You kind of feed the information into board docs and it automatically populates it for you. And you're like, well, I don't want the actual resolution up there yet. You know what I mean? So we can have those conversations.
And here's what about financial warrants, et cetera? Are they required to be available to the public?
I believe so. That's, that might be worth a follow-up conversation.
Okay.
About what kind of specific information you're talking about. But I would say in general, financial information is, kind of the pillar of what they want the public to be able to see.
Right. Yeah. even if they're not discussed in public, there should be copies available, right?
Right, because it may be a very pro forma, the board
Right.
approves of something, but in theory, the public should have the ability to see what the board approved before they approved it.
Okay, any other questions from the group? Heather, thank you so much. We appreciate
You are
your time
welcome.
and your expertise. Looking forward to
I was
God
gonna say, I will
willing.
see everybody on the fourth Wednesday of February in 2024.
God willing, yes.
And
2023.
I will speak with a number of you probably between now and then. We're here when your election stuff starts heating up and kind of for general increase. So with that being said, thanks for your time this morning, everyone. And I will see you soon and talk to you soon.
Thank you so much, Heather. Have a
Bye-bye.
good one. Thanks.
Bye.
Bye-bye. Okay, I think we got most of our questions addressed from Heather, and I got to tell you, she's just a phone call away. And what I also like about the Farrar firm is that, even if you're not a customer, oftentimes they will help you. So, again, they've been very generous with their time working with our group in Central New York. Of course, it helps that Ben Ferrara, the founder, was really got his start in this area. So, and I'm sorry for any of the new people. My name is Jim Van Wummer. I should have introduced myself. I've been around for a couple of years now, and I'm the coordinator for board training for the Oneida-Madison-Herkimer School Boards Institute. It's quite a mouthful, but again, we are here to help you. If we don't have the answers, we certainly know how to get the answers, both from our legislators, from the regions, from Albany, or from our local people. So thank you so much. And I do appreciate Heather giving a great segue to our policy side. Christine, I know we're a little ahead of time right now. I don't think anybody's going to be objecting if we move into your portion of the program. Why don't we do Christine, where are you? You all set?
Yeah, we're all set. I just need to share my screen.
You know what? Let's do a 5-minute break though. Okay, Christine? Okay. All right.
Sounds
and
good.
we come back at 10:10 and we'd share screen and be good to go. Okay?
Okay.
And Christine, you can get on, I think, right now. I mean, you can share it if you want to.
Okay, thank you.
All right, looks good.
Boy, there's a lot of new stuff going on. I'm glad these meetings, I like to have input, you get information from a lot of people. But a lot of this stuff really is meant for Kathy because she's the board clerk. And it's kind of ridiculous for me to do more information that she should know. Oh, okay, yeah, that's what I just.
Hey, Christine? Oops.
Yeah, can you hear me okay?
We can hear you, and I just want to let everyone know, the other side of our group, with our SBI group, we have the best support team in the world, and Charlie Prioria. Charlie's just phenomenal, just a great lady. And she certainly is probably the first line of defense here when we have questions come in. So Charlie is a godsend for our group and for everyone else. So without any further ado, we can, Christine, start with your piece. If you want to give us a quick background on how you ended up in the position today, we can go from there. And I think you have someone else with you, right, Christine?
Yes. Yep. Today, I'll be doing the presentation with Vera. She's also in our office, and she works alongside me and Katie Parker and Dave Pello, who's also one of the attorneys in our office that works on policy matters. And today we're going to be talking about district clerk functions and board policy. So we're going to get into a little bit about the process generally, and also a lot of what we're going to be talking about today is the process that we do here at our policy service at Madison-Oneida-Madison-Herkimer. We know that some districts don't necessarily use our service, and that's okay. Generally speaking, the process of policy development is generally the same. There just may be some processes that we do that maybe your service doesn't do, but it's just a general overview.
Right. Thanks, Christine.
Yeah, anytime. And if there's any questions, just put them in the chat. I'm not going to be able to see the chat, but Jim, if you can just let us know.
Will
if
do.
there's a question.
Yeah, will do. Thanks.
Yep. All right. So school board policy. Policy for the school board purposes is a statement that establishes the standards or objectives that are sought to be obtained by the district. We talk a lot in our office about how it's important that board policy reflect the educational goals of the district or the BOCES. And I think, as Heather mentioned, that any policy be adopted through proper board procedure. Usually you will have a policy adoption process, and you just want to always make sure you're following that. Some districts also have a board policy committee that may review the content of the policies and make any revisions throughout the process. And they also discuss how those policies are going to be implemented. One of the parts we're going to talk about today is the dissemination and implementation of policies. That's always very important, and sometimes that falls on the district clerk to make sure that those staff members who may be named in policies be notified of where they're named and what their new responsibilities are. So something, for an example, would be a compliance coordinator or a Title IX coordinator. In those policies, you have to, or the DASA as well, you have to nominate whoever that coordinator or Title IX compliance coordinator is going to be. You want to make sure that's done and that those people get those notifications. So we're going to talk about that a little bit today as well. So your board policy manual is made up of 9 sections. I'm sure many of you are familiar with these. These are the general section numbers. We have general commitments in your zeros. Your community relations policies go in section 1000. You have school board operations, 2000. Section 3000 is administration. And then fiscal management, support operations, and personnel are 4, 5, and 6,000. And students, policies related to students are in 7,000s, and your instruction policies are in section 8,000. Again, these are the sections that we use. They're not necessarily always standard. We've seen some situations where they'll flip a section. So if you have Erie 1 or you're using NISBA, these sections may not go exactly with yours, but the idea remains the same, that generally speaking, your board policy manual will be set up into sections similar to this, so that it's easier to find. Your board policy manual, districts oftentimes have these online. There's no legal requirement that you have a paper copy or a hard copy, but we do offer, in our service anyways, a binder to a district so that you do have a hard copy. Online, I have an example here. I'm hoping it's going to show you guys what this is. Can you guys see that? Or, I gotta share screen again. Can you see that table of contents on the screen?
Yes.
Okay, so if you're in our service, this is the an example of a table of contents for one of our districts. And as you can see, there is a search function. Vera, I think you have a good idea of how to use that, or better than I do.
Right, and whether you're using board docs or you have our service here, the search option for your online policy manual is great when it comes to you're looking for a certain policy, as long as you know a keyword like bathrooms or field trips, anything where that word will, it'll search the document, not just the title, and it'll pull up your policies that have that term in it. And then you can select to choose from that list the corresponding policy. So if you're looking to see if you guys have a policy or what's the procedure that goes with that policy, it's a great way of looking it up. Regulations as well, they'll pop up. If you ever have any personnel changes, if someone leaves and you need to say, oh, I want to know where that person that was listed as our Title IX coordinator, everywhere that their name appears, because there are some policies where you do have to put in that person's contact information, or your superintendent changes. That's a great thing. You just put in their first or last name, and up will pop up every policy and regulation where that key person is listed. And then now you know that those documents need to be updated. So it's a great tool to have in your pocket, and also to share with other people within your district or your board, because it really does answer those questions quickly, and really does provide your information to be on hand, nice and quick.
Yeah, and one thing I want to note here is if you are using a hard copy, something that we've run into And I've tried to incorporate into this presentation here today some frequent comments we get or questions that we get. But one of the things we get about the board policy manual is some boards ask for, let's say 10 binders. So that would, I think it's an extra cost if we're going to give 10 binders versus one. But let's say your district in particular has one hard copy binder for each board member and the superintendent. And that's fine. Not everybody wants to use the electronic versions. But the one important thing to consider is whenever you change your policy, there's a deletion, a revision of a policy, each one of those binders needs to be updated. You'll want to print 10 copies of, let's say, your new Title IX policy and make sure you remove the old one and put in the newest one. And that's especially important if those binders are used, for new board members, or you just, take it from your retiring board member and you're giving it to a new one who's just coming on, that everybody has the same content in each of their binders. All right, so now we're going to talk about policies and policy development, generally speaking. Again, this is our process, but most policy services are going to work in a similar manner. So we review existing policies that we have, we update, we send out updates as needed. We'll talk about that more in a little bit. But the reason we do this is there are constantly changes happening in federal and state laws, as well as regulations. We've all experienced this in the last 2 years. There have been many changes to regulations, for example, legislation. I think there was a reference to employee time off for employee voting. That was a couple of years ago that happened. So there's all these changes. We've had COVID paid leave in the last 2 years, and many other COVID related legislation that has changed. And they are, when we see those changes, what we do is we look at them and see if there's a requirement for school districts to have a policy. As many of you know, there is a short list of mandatory or required policies. However, the reason that most districts, have approximately 300 policies are because, they're coming from other places. There may have been an audit from the comptroller that said, this isn't legally required, but we think the district needs a policy. One of the most recent examples was a couple of years ago. There were audits coming out that said that there should be a reserve fund policy. There's nothing in state law or legislation which requires a reserve fund policy, but because many schools were getting audited for that purpose, that was developed as something that we offer to our districts. So there are court rulings as well that happen that may change different laws. There are federal laws, FMLA, for example, in the beginning of the pandemic when there was federal COVID leave, the legislation used the word policy, that public entities should have a policy regarding federal COVID leave. And unfortunately, there's this, if you can see our last bullet point says policy versus policy. It was unclear in the legislation whether that was a board approved policy. Was that what the government was referring to? Or were they just talking about a policy like a procedure? And they are two very different things in school districts. And unfortunately, the legislatures, both state and federal, don't necessarily always point that out. So we evaluate as part of our policy development service, try and figure out what they're talking about if it's not clear. And if it is unclear, develop policies that you can use if needed. So there's also other reasons. One of the options up on the screen you'll see is internal request. So again, why that number goes from our about 40, I think, required policy list to 300 is not just for comptroller audits and other recommended legislative reasons, but also we have the internal requests. So we might have a district that, for example, allows for students to drive their snowmobiles to school. And they want to have a policy on what the students must do in order to be allowed to do that, or what rules are associated with that. And so that's an internal request for a policy that either that school district develops and we review, or they ask us to develop that policy for them. So all of these things, local preference, past situations or problems may have prompted additional policy actions. And that's how that policy binder, whether it's electronic or in hard copy, gets so big. We tend to try and write our policies in pretty broad terms with clear and concise guidelines. It doesn't always happen because there are times where we have to get into the legal process. One of the most recent examples of this would be our Title IX. When the rules changed recently on Title IX, they are very, very specific as to what that procedure needs to be and everything that needs to be in that policy. So it's unfortunately written in a way that is sometimes difficult for a community member maybe to kind of sort through and read, because it's in this, what we call legalese. And that's, again, because the law requires it. DASA is the same thing. So that's a little bit of a longer policy. Your EEOC policy or your harassment policy, anti-harassment policies are often also written in a more, in a way that is more about the legal process and has all of those procedures in it. The other reason we sometimes do that is, your policy book is where, if you have an appointment of a DASA coordinator or your Title IX coordinator, your under the New York State anti-harassment and EEO laws, your coordinator for those, if a complaint comes in, you want that policy to be a guide for that person as to how that investigation may have to go. Now, this could be done in a policy or a reg or both. It really is up to the district on how they want that delineated. So the other thing I wanted to talk about here is, and before I get to this next slide, I just want to note that there are some policies that, again, where we're talking about not board approved policy, but just policy, which I like to use the word procedure just to delineate between the two, but not all issues do require a board adopted policy. And a couple examples of those I'll give is remote learning. At the start of the pandemic, there was some concern about whether or not boards had to approve remote learning as what the school was doing, or had to change any of their current policies when they talked about instruction to include the words remote or distance before that, or virtual learning, any of those three throughout their policies. And there was, a lot of concern, because if you do the keyword search that Vera just talked about for instruction, for example, there's going to be quite a few policies that you would have to include in parentheticals, the words remote, distance, or virtual learning. And that would have been a hard lift for boards at the time when they were worried about other things. And there really wasn't a need to do that. When we looked into it, we looked at, okay, we're talking about instruction. It doesn't limit it to one person, so that's okay. Another example would have been, again, the COVID-19 paid leave for New York State. There was no requirement. While there's a requirement that the school districts and other public entities follow that law, there's no requirement that there be a policy in place, policy, capital P, board approved policy. There just had to be a procedure in place for school districts to handle those requests as if they were any other leave request, and make sure you were following the board policy. So district clerk functions that are related to policy, we listed some out here. The district clerk is usually the liaison with our service. You're usually the person who maintains the adoptions, revisions, and deletions in the board minutes. The person keeping track of all of the policies and regulations that are still in draft or that are at different stages of the board policy process. Again, this depends on your board's policy on this. Is there a first read? Is there a requirement for a second read? Those types of things. So oftentimes you're talking to our office or your policy service office about things like, okay, you know, we have had this policy in draft for a little while. We're taking this to the policy committee next month, or, you know, these policies have gone through the first read. We at our district don't do a second read, so they've been approved. Or maybe telling us, you know, they've gone through the first and second read and now they've been approved. So you're kind of tracking all of that stuff. We don't know we don't always know when your policy committee meetings are or what happens there. And we don't need to know that. We just need someone to keep us updated and or your policy service, if it's someone else, updated as to where you are in the process, so that we can finalize policies and get them uploaded, send you clean drafts and update the dates of approval on the policy itself. Disseminating approved policies to applicable persons and departments. It's another thing we talked about. So some of the policies, as you know, have notification requirements to maybe the community or to your staff members. So it would be important to know who's doing that. Again, that's something that's sometimes talked about in committee meetings, policy committee meetings, when you're figuring out, okay, who is the person we're designating as the contact person or the person who's going to be responsible for this. And then also asking, okay, once this policy is approved, who's going to send it out to everybody? And sometimes that is the district clerk. And again, that may include required annual notifications. And of course, just being aware of the policy process with the service that you're working with. We are always open to emails and phone calls if you have questions about the service or you know, what we do, what our process is. And so you can better understand that. We're always open to discussing that. Vera, did you want to talk about that? Okay.
So depending on, you know, which policy service you have, a lot of times the process is kind of the same when it comes to adopting or revising or deleting your policies and regulations. Usually there's, if you're going through, you request a draft be kind of pulled by your district to look at, or if you're in an audit, there's draft policies and regs that your policy you know, office will put together for you regarding whatever the topic is, whether, like I said, it's required or requested by your district, or it just comes up for audit. You should be able to note the draft date so that you know you're working with the most current draft copy that there is. I know sometimes, you know, one draft will do it, and other times it kind of goes back and forth until everybody kind of agrees on the language. You'll see that the strike throughs will be recommends of deletions, and underlines typically are to flag any added or new language in that policy. So that way, or the regulations, so that you can see how the language is changing. And that's really helpful just to track. Sometimes after a new number of revisions, it gets muddled, and it's nice to see what it was versus how it is. And sometimes it reverts back. So those you know, flaggings are really important. And again, when it gets too muddied, sometimes it's nice to just say, this is that draft as of now, this is how it reads. And we can go ahead and like replace it from, and instead of saying renumbering or revising, we just say replace. And here is that reg or policy as it stands now, which really does kind of help to see what it's turning into. And usually if that's the case, your policy number will be there as well. If it's getting renumbered, it'll be there. And where if it's keeping the number, it'll say replacing 242 and staying as 242, just so that way, as the process goes through, that it's easier to keep track of.
And these next couple steps is where your district or your BOCES during policy committee meetings and kind of go through and decide, is this what we want? Do we like this language? Are there any changes that we want to make? You would make those changes, and your contact person, again, usually it would be you, the district clerk, would then advise our office of what those changes are. I just wanted to pause here and make a note about how you advise the policy service office of those changes. There are various ways to do it. Our office uses Microsoft 365, so we send everything in Word. So if you have Word and you use Word, then you can just try and use the strike-throughs and deletions, but usually I would say 95% will just simply print off, and work from a hard copy and make those changes, right on the document, as long as they're written legibly. We don't want to have, to bother you trying to figure out handwriting. But again, that's something we can work with as well, and try and figure out what those changes are, and how best to implement them. But again, you don't even have to, you can have your policy committee meeting and then go into your board meeting and adopt that policy that night, as long as your board policy allows for that. So again, just got to make sure that there's an allowance for that in your board policy. And if it's not, and that's something that you want to change, we can obviously work with you on that language. We have different options for first reads, first and second reads, and first and second reads with exceptions. So we have lots of templates that we can help your district to help that process and make it easier for everyone involved. But the biggest thing is that we just need to receive information about what those changes are that have been made at the policy committee or made the night that the policy has been approved, so that we can make sure when we upload them or your policy service uploads that final draft, that it is the draft that has the most recent changes, those changes that were approved by the board. You don't want to accidentally upload a first draft and not the final draft. Number 6, again, we prepare the revised draft policies with the changes on it. We would send those back to you. And then that process is repeated until the board's final adoption of each policy. Sometimes it does take a couple revisions, especially if it's a complicated policy and there are questions about the substance, or maybe why there's a reference to a legal reference to a specific law or piece of legislation, or why did we include this piece of the law right in the policy? We don't always do that. We try to put it into more informal language that's easier to read for everyone involved, especially the community. But sometimes we have to keep something in there that is directly from the statute or the legislation or reference to a case, a court ruling or something along those lines. And there may be questions on that, and that's okay. Everything that we send in a month doesn't necessarily have to be approved the following month. So, you can call us, ask us those questions. We can get you the answers. And then if you have another revision or a board wants to make a change, a board policy committee wants to make a change, they can do that as well. In terms of deleting policies and regulations, it's the same process. Once the board has approved the deletion, there's just a couple steps, and that's just notifying Katie or Vera in our office with the date that the deletion occurred. Again, that's to make sure that we keep your policy book that's online updated, as well as the hard copy that we keep here as well. So that date of deletion being included, we will then take that deleted policy and archive it. We'll talk about that in a second, but those policies, your online policy manual does have to be online up on the website for the public to access. So we want to make sure that's current. There we go. Already talked about this a couple times, so just kind of going to skip this. But again, first readings, And then your second reading is not always required, not required under state law to have 2 readings. And that is section 2000 of your school board operations, if you want to check and see what your district does. We also maintain a history of your policies. So we keep all of your deleted policies, all of your revised policies. We archive them electronically. And so if you have been in our service, once you enter our service, you provide a copy of your most recent policies, and we keep everything from that point on. So we could go back, and if you've been in our policy service since 1996, we could go back and see a history of all of the policies that you've had and how they've changed over the years. This becomes important because there are times when there may be a case, a legal case that the school district is dealing with, and they need to go back 5 years and see what their policy was, you know, in that year, because it's changed since then. It's also why, if you notice on the bottom of your policy, you will see, you know, the adoption date, and then you'll see the revised date. So you'll see every time that your policy was revised. And again, we won't have anything from your district prior to being in our service, but we do keep everything from your entry into our service until for the length of time that you're in the service. Most of the bigger services do that as well. We also recommend, though, because technology can be fickle sometimes, that you as the board clerk also archive those deleted and revised policies and regulations, not only for purposes of just in case the technology fails, but also because you may need access to that policy quicker. So if you get a FOIL request, for example, and you want to access those policies, you want to be able, you don't necessarily want to have to call us and then we get you the policy. You may need it quicker. Your attorney, your school attorney may need a copy of a policy from last year that has since been revised. And it just sometimes is easier to access. So we always recommend that backup, but just so you know, we also keep a backup here, and then the RIC has a backup of our backup. So we always have that archive for you. All right. Again, just some steps about dissemination and implementation. These are just things to think about during the policy development process, as well as afterwards. Once it's been finalized and uploaded, you provide your notice. You also need to ask who the person is going to be designated to implement that policy. Oftentimes this is the superintendent, or maybe an assistant superintendent or deputy superintendent, or it may say superintendent or designee. Well, who is that designee? So that this district is aware of who is going to be implementing that policy. It helps for you to know that because you are probably going to be the one that gets the phone call about that policy and wants to know who the DASA coordinator is and has a whole bunch of DASA questions, and you'll want to know who you can direct that person to at that point in time. It's also helpful to know the implementation process or who's going to be doing that, so that if anything isn't working, someone is keeping track to know what changes to look for the next time around. We'll talk about the audit service in a second and how we kind of go through that and go through each policy section separately. So, all right. So like I said, we wanted to also hit a few of the frequently asked questions that we get. This is probably one of the top questions that we receive about policy, and that's, what is the difference between a policy and a regulation? They're both very important, but a regulation follows your policy and your board manual. So we have an example on here. We have a fingerprinting policy that is 6,400. And if it's a regulation, we always have a 0.1 or 0.2 after it for each of the regulations. The difference between the regulation and the policy is your policy is adopted by the board. Your regulation is not. Now, I'm going to talk about an exception in a second here, but Your superintendent of schools is the one who generally approves regulations, so it does not require board action. If your regulation is adopted by the board, it is considered a policy. So that's something to be aware of. This question comes up a lot from districts, both school board members as well as superintendents and clerks. You cannot change a regulation if it's been approved by the board without the board making the change.
Christine,
yes.
so typically then with a regulation, it's presented to the board just for their information and not for their approval.
Correct. Yep, it's for information purposes. So this may be like behind your FMLA policy, which is a required policy. You might have your FMLA form that the person is going to fill out if they need to use it. You
Right.
wouldn't typically want that form to be approved by the board
Right.
because the form may change.
Right.
So if it's superintendent approved, and usually somewhere in the policy, it will say that the superintendent has been given authority to create any regulations necessary for this policy to go into effect. And then that's when the superintendent can then approve the regulations.
Yep.
So
Oftentimes, Christine, we get into that, especially with John Q, the student handbook. You know, John Q, the public thinks, oh, the handbook is the district policy. Well, typically a handbook is all regulations, you know, cafeteria time, blah, 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 all of that in students' information. So.
yes, that is usually instructional information, like you said, times, calendars, things like that. They may be referenced. I think there's a school calendar policy, but again, it just states that the board's going to set the calendar, and then in your handbook doesn't need to be board approved. It's just a collection of all that information in one spot. Yeah.
And we do have a question, Christine. Is there a requirement to notify the public of new and or revised policies other than posting them on the website in the policy manual that's available to the public?
So is there if you're asking if there's the state law that would control that would be your minutes. I think Heather talked about that. I think she mentioned that your minutes have to go up within 2 weeks, right?
Yeah.
So in your minutes, you're going to have your policy approvals.
Okay.
So I would say that you want to get your policies up in a reasonable amount of time thereafter.
Right.
So it's a requirement, but it's kind of under the minutes.
Got it.
And it does have to be available to the public and accessible. So you want to make sure your website is accessible as well under the Office of Civil Rights requirements. So
Okay.
wherever they're going, which I believe ours are. Ours are PDFs.
Thank you.
Yep. All right, so another question that we sometimes receive is they received a policy audit section. What do I do next? So we have a specific policy audit service. We actually have 2 levels of service. Our first level is level 1, right, Vera? And it's 10 you get 10 policy changes, let's say, or revisions a year. Our policy audit service means that is our level 2 service, and we are going through about 100 policies a year. And so we will go through your whole policy book in about a 3-year period. We work with the district and we talk about, okay, what section do you want to start in? We can move around if necessary. I can tell you that COVID kind of, threw everybody for a loop, and, us included. So there wasn't necessarily a following of schedules so much as trying to keep up with the new legislation and new policies that were coming out. But we do send approximately, 5 to 10, depending on your district's preferences. And the policy audit, being in a policy audit, again, whether it's our service or any other one, allows the district or BOCES to really stay up to date with your policies. It's a continuous process. Your policies are constantly changing. We've had one change to Title IX, and there hadn't been a change to Title IX legislatively anyways, or in regards to the regulations in 2020, and that's going to change again. So we're expecting that change this spring. So usually, you know, that's not necessarily normal, but that's why a policy audit is so important, because you're constantly going through the process. So you're able to stay up to date with the legislation. And again, any new policy requirements that come out, we do send out updates, which we're going to get to in a second. This is a sample of how we use our policy audit. I'm going to let Vera talk about this next one though, because she's a little bit more familiar with that.
Right, so typically when we do a section audit, we like to send you an audit table of contents. It just kind of helps not just the district clerk, but also the board members see the stage of that policy or regulation, what it's numbered currently, if it's going to be replacing or renumbering a policy or regulation that the district already has in place. As you see for the first one, 5001, we state the name of the policy, and underneath that, if we're sending an update that goes along with that policy so that the board or your team has a better understanding of why we're changing this policy or what changes happen. It's also because when you see the sample of a policy update, it does go into the whys and the whens of why something has changed. The purpose will be a revise if that's revision, or it could say, like towards the bottom, 5401, it'll say new if it's a policy or regulation that either the district requested or that we see that you need. For 5003, that's another example of just it's been renumbered from 5010 for a revision. And then there you see the regulation that goes with it, just like Christine had said, it's a 0.1. And that one just says superintendent approved. And it kind of states at the bottom, superintendent may approve, no board action required. If by any chance, sometimes it's an old policy and you might have had the reg kind of smushed in with the policy and maybe we're splitting it now, we'll actually say it's a regulation, superintendent may approve after board rescinds. So you'll actually see on the body of that regulation, it'll have a spot for the date for your board meeting where the board rescinds it and says, we understand this is no longer a policy. And then it'll have a line for superintendent approved date. And now it becomes a regulation. We've split it and now it becomes the reg and it's the superintendent's responsibility to approve. So you'll kind of see that delineation as well, but that explains the reg. And then anything that is required, we will go ahead and highlight that as required to make sure that you're meeting the needs that the law states that you have to have, or any sort of statute that's out there that says you're going to require this policy, you need it in there for those audits. It'll be there and it'll be labeled. Those are, you know, your hands are tied and that's what we need to do. We want to make sure that we are meeting that compliance. So that will be labeled as well.
Yeah, and the thing, you know, when this form has been used for by our office for a while, Jennifer Russ, I don't know if she started using this form and created the form or if it was used before her as well, but it really is great and it allows you, the district clerk, to kind of, you know, just circle at kind of as the policy committee meeting and your board meeting are happening, kind of circle what's going on, you know, was it approved or not? What was the date of approval?
Right.
And then you can just send back, you know, scan that in. That's what a lot of districts do, is they scan in this table of contents sheet with their notes on it. And then the policies that they may have been taking notes on during the meeting or something like that, and then email all of that to us and we can just go through and work off of your notes. So it kind of helps that process a little bit.
Right. And sometimes they're not approved. Sometimes, you know, the approved or the deletion is a no. And so we know that that needs to be looked at again. And that's a great way of keeping track of what's going on, not just for you, but just to know the lifeline of that policy or regulation as it sits. So sometimes something has to get tabled. There's more questions, your board requires more information, and that's a great tool for you to have so that you know we don't understand why we need this. We don't know why it's required. and we need more, information to move forward. And it's a great way of also putting pause on some things.
Okay, so the next question, I received a policy update. What do I do? So periodically, if you're in our level 1 service or a level 2 service, we will periodically send out update bulletins, approximately 8 to 10 a year. I know there was about that during the pandemic, and many of them were pandemic related. And we describe the changes that we think are recommended by new laws or administrative decisions. This may require that your particular policy on that subject be revised, or in some cases rescinded, or a new regulation set or something along those lines. Even when the subject matter is required, there's usually something that the district or BOCES has to decide. We often have those within our policy update. I'm going to show a couple examples here. So if you just give me a second. Share the screen. So this is an example of a policy update. You should be able to see it. This was from February 19th, 2021. And this is in regards to the district-wide safety plan. And Heather actually talked about this topic. It was the change that was made to the legislation that now requires certain protocols. In this case, it was for the disaster emergency plans. We had also sent one out prior to this on the SRO agreements. So whenever anything like that happens, we are going to prepare an update, and we give you the information so that you can provide to your board and your superintendent what's changing or why. So the first section of our update always covers the why we've prepared the update. And some of these are very lengthy. Some of these are one page. They changed a word or they extended an expiration date. But this one talked about, again, the pandemic plan is what is that has to now be incorporated into your district-wide safety plans. This is not the HERO Act, which you'll hear a lot about, though that is not applicable to school districts, but this is the public school version of the HERO Act. And all of this has to be in there. And then we also include recommended steps. So in this case, we ask that we ask the districts to review their district-wide safety plan and determine if they had to make any changes to it. And then also we note what changes to the policy. We send along, when we have something like this, usually sometimes some guidance. In this case, we sent along the NICED memo. So again, that's more information for your board to put in the board packet when they need to review it. And then the law. So this came from Westlaw, and this showed exactly what the new changes were, because this was fairly comprehensive. And then if there's a change to either a new policy, we will often send, or a revision to a policy, we will send a template of that. So if I can get back there, it's here, right? No, not there. Okay. And this is so Heather, actually, this is the one that Heather talked about, the gender neutral bathroom facilities.
Yeah.
So in this, again, this is short compared to the other one. Why we prepared the update, the recommended action plan for your district, who to contact at our office with where you wanted to put that. And then this was our draft policy. Again, this was a short one page. This is the policy that you can then take and place in the board packet with any additional information that your board may need or your policy committee may need to review at their next meeting to decide whether or not to put that into place. And again, every service usually has some sort of policy update mechanism. So All right, and our last question that we often get is about Google Docs or Board Docs and whether or not our process at Madison and Oneida-Madison changes if you're using any of these. I think I mentioned that we generally use Microsoft 365. So we don't use Google Docs here at our office. I do know that Google Docs does allow for, you can download into a Word format. So there's nothing, your board can use that if they're using Google Docs to make changes real time, things like that. You can absolutely use that and then just download it into Word format and send it to us. You just need to make sure that the changes show up for us to see. That's the biggest thing. Again, you can handwrite them, whatever works for you. And if you're unsure, you can always call our office. And technology changes all the time. Everybody has different software and apps and things like that, ways to communicate. And we are happy to discuss that with you and try and figure out a way that can work. We can't do everything for every district. We have 41 districts, I think, that we work with. So that's quite a few, and it's 3.5 person staff, basically, 3 or 4 people. So we can't use every different app and software that's out there, but we will try to work with you. For Board Docs, we know districts do like to use Board Docs for their agendas and minutes, and some are moving towards using that for their policy, putting their policies up there as well. We do not use Board Docs. I don't know much about it. We have a couple districts that do use it, and the way that we have worked with them in that situation is usually because of administrative rights to that system. And it's password protected and all of that. Their district clerk actually does all of the uploading, and then they send us PDF versions of the finals so that we have a backup and we know where to start from in that audit process. So we're going through each section so that we have the most recent version. So if you're using Board Docs, again, you can call us and we can talk about that and how to best work with that and your district or your BOCES to get that accomplished. So that's all we have. So I don't know if there's any questions out there about policy or policy process or policy development, but we're happy to take them.
Christine, here, question here, I guess. You said most districts have in their board policy, have a step 1 and a step 2, correct?
So they can, are you talking, you mean a first read and a second read?
Yes, first read,
Yes.
second read.
Yeah, every district is different. So what I sometimes see, I don't know I think our template is a first and a second read, but then there's an exception where the board can waive a second read.
Thank you.
Yeah.
If it's a real hot topic, sometimes boards, again, have to jump the gun because of the local politics involved.
Yes, and sometimes there are timing issues as well. Something has to be done within a certain time frame, and it has to be done right away. We do have a couple districts that have moved away from having the 2 read requirement in their policy, only because their specific policy committee is very active. And so they do a lot of the work already in the policy committee. And by the time it gets to the board at that first read, it's basically ready to go. So, again, it's personal preference for the district.
So they can do that. And the other, I know the other piece is keeping up with the policies. In that audit, I got to tell you, it's just a great service for districts and for superintendents and for board clerks, because otherwise it gets old pretty quick. And then all of a sudden you've got, 300 policies that you've got to take a look at. So.
Yes, and we have had districts come into our service, or we look at their policies, after they haven't been with us for a while, and it's been, some of their policies haven't been revised in quite a long time. I found a couple that were 1982 or 1996, things like that. And you always, if you're going through that audit service, even if you don't change the policy, you can at least put a revision date on the bottom so that you know that you have looked at this. It has been looked at since 1996, at least once.
Right.
So that it's up to date. And we are always checking the legal references as well. The legal references you'll see on the bottom of the policies that we send anyways. We try, our goal anyways, my goal is to check them annually. It's a lot to keep track of, but I think it's very important that policies, wearing both hats, both as a labor relations specialist and a school attorney, I think it's really important that the legal updates or the legal references be accurate on the bottom of those policies. So,
and also as a district clerk, the responsibility of knowing which policies have to have an annual review.
Right.
I see a couple of districts sometimes where the code of conduct kind of slips by and, that needs an annual review. There's a lot of policies too. I know we make a list that kind of says, hey, you might not need a policy, but this has to get reviewed annually anyway, your procedure, your things in place. And there's a little bit of a checklist, a couple of them that do have to get reviewed. You don't have to revise them and everything, but they do have to get reviewed annually. And you guys have to know that or ask for that document that I know we've already provided this year.
Yes.
Kind of went out. Gotta keep abreast of that as well.
yeah, and if you don't have a copy of that, we could send that to you. So if you're wondering what those policies are, because it will be here in just a few months, your annual meeting and all of that.
Yeah.
And if you don't have a copy of our most recent update that had all that information on it, please just email Vera or myself or Katie, and we can get you a copy of that. So you're ready to go this summer, June. It'll be here, June and July. It'll be here before we know it.
And the other thing with those annual updates, again, those are the pieces that the OD loves to get and say, oh, wait, district's out of compliance. And, again, just bad PR for everybody.
Mhm.
So
Yes. Yep.
now the other side is with your legal updates. And again, you provide that whatever level they're at, either level 1 or level 2, right?
Yes, that comes with both levels of service. So whether you're only reviewing 10 policies a year, or if you're in our full audit, you will still get our legal updates.
Right, there's no limit to those. As many as we put out is how many that we'll do up for you. So even the first policy, level 1 is just, they can request 10 policies, but when it comes to our updates, if we put out 25, you're getting 25. It's ours. So that's different. That's keeping you guys up to date and compliant. That's totally separate.
And the other thing, Christine, is like you can send models out. So if a district says, hey, listen, we're looking at something in this area, do you have any policies, that are available to, models to review, correct?
Yes, we have, we will do that research for you, and we will find sample policies on different topics. And we get all sorts of questions. One of our more recent questions was about, we had a district looking to split their single district into specific election districts.
Oh,
So
okay.
they wanted to see information on that. We've had a district looking for district clerk policies. It's not a required policy, but we've had a couple that have won a policy or have had a policy that outlines the duties of the district clerk, and we provided samples for that as well. So
yeah, and I guess if there's no other questions, I got to tell the clerks that having your policies readily available online is just probably one of the best services for board members, because oftentimes when they're shopping at the grocery store, at the gas station, somebody will come up and say, blah, blah, blah regarding this issue. And their first line of defense is, well, listen, have you checked our policy? Whether it be online or hard copy. I think everybody's online now, I think, in our region. But it makes such a difference, because oftentimes, they will go back, look at the policy, and that's the last time, they hear from them. So it's just a great line of defense for school board members to have that policy outlet readily available. It really helps them and protects them oftentimes. So. Any other questions for the good of the order for Christine? or Vera? All right, well, thank you.
Okay.
Thanks, Christine. Thank you,
All right,
Vera.
Thank
Appreciate your
you.
help. As always, have a good one and good luck.
All right, thanks.
Keep up the good work.
Thank
Bye.
you.
Thank you. We're done a little bit early, which is, I think, okay with everybody. The only other thing is that we were looking at, taking a look at a round table. If there's any questions or issues or challenges you have, if you'd like to talk about it now, or you can email me or Charlie to take a look at. From our calendar perspective, I know some of you are getting requests for petitions, and we do have some models available. So if you would like a model, what you hand out to prospective board candidates, again, you can give Charlie an email or me an email, and we can get that to you. As far as dates, we've got coming up the end of March, and we'll be sending that agenda out. It's so you want to be a school board member and what to expect if elected. So that's on a Saturday morning that we conduct that. And then in our calendar, if you take a look at our calendar for this year, we have the required trainings for the new school board training in June 9th and 13th. And then we have the FOT training, the 16th, and then the, let's see, 16th and the following week, the 20th, I believe. So that's the FOT and the new school board training. And like we talked with before, our Student Achievement Awards and our DSA, Distinguished Service Award, will be going out in a packet to you to distribute to the superintendents and to teachers for hopefully nominations. And we're going to run that virtually like we did last year on May 12th for the Student Achievement Award, and then on May 26th for the SDA. We want to keep it separate because it really worked out as well as it could last year with the students. So that's what we have so far. Let's see, anything else for the good of the order? Charlie, anything else?
I don't think
Charlie?
so. I think you said it all. Again, the for those who didn't hear, this workshop will be online on our website at herkimerboces.org. Probably not until next week, but you can
Yeah,
access
that's
it.
fine,
And
Charlie.
I'll send out the PowerPoints to everybody that was sent to me.
Okay. Well, without any further discussion, questions, thank you so much for your time, and enjoy the rest of your week. And next week we'll be back at it again. So thank you so much, and have a good one.
Thank you.
Bye-bye.
Bye.
Have a good
Thank
day.
you.
Good day
Thank
and a
you.
good week.
You too.
Thanks. Yeah, thank you.